Hello and welcome to the Legal Scoop, our webinar series here at LOMAD, where we talk about recent Third Department and Court of Appeals decisions. I'm Brendan Shannon. I'm an associate here at LOMAD, and every month, we like to just talk about a notable decision that we think you might find interesting. And this month we have Epstein v. Waldbaums, which is a case from May. It came out May 1st of last month, and it involves the extreme hardship provision under the law. Now, specifically under Section 35(3), if a claimant has an LWEC above 75% within 1 year of their PPD benefits being exhausted, they can apply for a redetermination of their LWEC based on a claim that they are going to have an extreme hardship if they're no longer receiving their comp benefits. Now, these cases come up a lot, and they're very fact specific, but they're also very important because obviously we don't want a reclassification after we've already litigated LWEC, in these cases years prior, because obviously the facts are going to change, and they're going to change most likely in favor of the claimant. So it's important to be aware of these cases and to understand some of the steps that we can take to get as much information as possible to be able to defend them effectively. Now, what's notable about this one, and the reason I wanted to talk about it, is that the claimant produced evidence. So when you're considering extreme hardship, you consider their income, their expenses, and any other relevant factors. And the court cites in this case that those relevant factors could pretty much be anything that they would normally consider at the time of LWEC. So age, work experience, physical restrictions, things of that nature, which we would argue should be causally related restrictions. Those are the type of sort of extra factors they'll consider. But when you're really considering extreme hardship, it is an income versus expenses mathematical consideration. And the reason this case is notable is that the court did affirm an extreme hardship finding, but more so off of those extra factors. So here, the claimant's expenses did not completely outweigh her income. So her income included, I'm just going to read from the list, workers' comp benefits, SSD benefits, and a small pension, as well as a small pension from her late husband. And then obviously the workers' comp benefits would be going away. And her expenses included rent, health insurance, medications, car payment, car insurance, cell phone, hearing aids, food, gas, and credit card debt. And it was determined that without her comp benefits, after she paid her rent, she would have $200 left over. Now, what's notable about this case is that the court then affirmed the extreme hardship finding because they noted that, the claimant was 75 years old, which is obviously an aggravating factor when you're considering LWEC. She had a history of 44 years working in manual labor as a meat packer, and she also had a recent diagnosis of cancer, which is obviously not cause related, but could be relevant. What's annoying about this case, however, is that the court did not go into the detail it frequently does, which makes me think that perhaps the record wasn't developed as much as it should have been with respect to the expenses that the claimant had and whether they were reasonable or not. Because you will find cases where they actually go into, well, yeah, for example, the claimant has a car payment and car insurance, but it's a luxury Lexus SUV or something like that. It's like, why does a 75-year-old person need that type of car? Or the credit card debt will be all consumer-related debt, things of that nature. And they'll also consider things like, could the claimant be on Medicare and have a lower premium? So the reason I want to talk about this case is because that's kind of frustrating, because when it's an extreme hardship case, we want to frame it so that the issue is more based on the financial consideration as opposed to those extra factors that make it sound like there should be an extreme hardship finding. So it's important to press your defense counsel when you have one of these cases to make sure that they're getting everything possible related to the claimant's income and the claimant's expenses. Because here I tend to suspect that there wasn't enough information garnered about the claimant's expenses, because while, okay, rent and, medical insurance and whatnot are obviously normal, reasonable expenses, there wasn't a lot of investigation into the reasonableness of them. So these are just things to be aware of. Extreme hardship is obviously something that does come up a lot. It is something that we, need to just get all our ducks in a row when we're defending. So that's all we have for this week. We'll be back next month with another case. And until then, please subscribe below if you like these videos. We've got a lot more video series here at LOMAD that I'm sure you'll like. Thank you.